Veuillez vous asseoir. L'audience est ouverte. La Cour se réunit ce matin pour entendre le second tour d'observations orales de la Fédération de Russie sur la demande en indication de mesures conservatoires présentée par l'Ukraine. Le juge Owada, pour des raisons qu'il m'a dûment fait connaître, est empêché de siéger ce matin. C'est, je crois, à M. Wordsworth qu'il revient de commencer aujourd'hui les plaidoiries de la Fédération de Russie. Monsieur Wordsworth, vous avez la parole.
Mr. President, members of the Court, I'll be addressing the submissions made by Professor Coe and Muzmani Cheek yesterday to the effect that Ukraine has put forward a plausible case of breach of the ICSFT. And it's useful to identify up front the points that I made on Tuesday as to which there has been no comeback. First, on the relevant test for plausibility, there was no response at all, and nor could there be. It's understood now to be common ground that the court cannot accept at face value the facts as alleged by Ukraine, and that the court must be satisfied that the arguments that Ukraine makes are sufficiently serious on the merits, and all the more so here, where the allegations are of a particular gravity. All that was said was that Russia is engaging in legal gymnastics. That is not correct. Russia is simply referring to the long-established requirement of plausibility and seeking to apply that test by reference to the evidentiary materials that Ukraine has put before the court. Secondly, there was no comeback on the fact that, according to Ukraine's own evidence, Ukraine itself is at least as engaged in acts of indiscriminate shelling that cause multiple civilian deaths and injuries. Not a single point was made in response to either the many OHCHR maps or the OHCHR data that show that civilian casualties from indiscriminate shelling are in fact higher on the DPR-LPR controlled side of the contact line. This is all Professor Coe had to say. Of course, this is a matter of considerable doubt and factual dispute, which will surely be the subject of evidentiary debate as this case proceeds to the merits. But any fair-minded observer of the eastern Ukraine situation knows that the overwhelming victims of such indiscriminate attacks have been Ukrainian civilians. In other words, Professor Coe sought to duck the issue entirely, resorting to what a fair-minded observer might think, albeit presumably a fair-minded observer who did not have access to or was unwilling to read the OHCHR materials that are of central relevance to this issue. Perhaps a point was being made on nationality of the victims. I simply don't know. It matters not. The critical issue for today is that there is no answer to the point that Ukraine is at least as engaged in the alleged acts of indiscriminate shelling that it now seeks to characterize as terrorism. And it is an important point. It places a strong question mark next to Ukraine's current characterization, and it has not been able even to begin to displace that question mark. As to Muzmani Cheek, she too said nothing whatsoever about the OHCHR maps and civilian casualty figures. With respect to the multiple OSCE reports that we have put before the court, showing that shells causing civilian death and serious injury in the area controlled by the LPR-DPR came from the areas controlled by Ukraine's armed forces, that is, from the West, she challenged just one instance. This concerned the shelling that hit a trolley bus in Donetsk on 22nd January 2015, killing many civilians. And she said that the OSCE report cited does not attribute this shelling to Ukrainian forces. Well, this is what the report says. The SMM, that is the OSCE monitor on the ground, observed 2 craters. At 11 o'clock, the SMM conducted a crater analysis on both craters and determined that the rounds that caused the 2 craters had been fired from a northwestern direction. The SMM also determined that the weapons used was most likely either a mortar or an artillery piece. And here is the OHCHR map covering a period later in 2015, showing the contact line which had not moved materially. So you can see where northwest of Donetsk is. It is plainly quite irrelevant that no specific mention is made by the OSCE of Ukrainian troops. The direction of fire says all that needed to be said. Mizmany-Chik also referred to a Guardian article where Ukraine is reported as denying responsibility, for what that is worth, and also that the bus may have been out of mortar range. But again, that tells one nothing. The OSCE says that the bus was hit by mortar or artillery. And the key point anyway is that that is all that she had to say. There was nothing whatsoever said about the excerpts from the OSCE reports that are at tab 25 of Russia's judges folder, which show how indiscriminate shelling in the DPR, LPR controlled areas has come from the north or west, i.e. the direction from which shelling by Ukrainian armed forces would come. There was not even a bare denial that there had been multiple civilian casualties caused by indiscriminate shelling from Ukraine's armed forces. Ukraine merely sought to pass the issue on to a merits phase. Third point on which there was no comeback. The fact that neither the ICRC nor the OHCHR nor the OSCE has characterized the acts of indiscriminate shelling at the center of Ukraine's request as terrorism. All that Ukraine was able to say through Mizmany-Chik is as follows. Ukraine, however, cites these documents simply as evidence that the events Ukraine asserts happened as a matter of fact. The determination of whether these acts are terrorist acts under the Convention is a legal determination that is beyond the mandate of those agencies, but not of this court. Well, there are 2 points to make here. First, if the OCHR and other documents are cited by Ukraine simply as evidence of what happened as a matter of fact, then Ukraine is accepting, as for present purposes it must, that the many instances of indiscriminate shelling by Ukraine that are recorded by the OHCHR happened as a matter of fact. One could take as an example the multiple civilian deaths resulting from the shelling of the checkpoint at Olenivka on 27th April 2016, as to which Mizmany-Chik had nothing to say yesterday, and as to which the OHCHR records that the mortar rounds were fired from the west, indicating the responsibility of Ukrainian armed forces. Secondly, Mizmany-Chik is anyway quite wrong. It is plain that the OHCHR, and in particular the ICRC, are making characterizations as to acts within the armed conflict in full knowledge of the applicable legal framework, and are describing acts and making recommendations accordingly. Their characterizations are not, of course, legally binding, but they do reflect what these organizations see as happening on the ground. If, in particular, the ICRC considered that these events concerned acts of terror, it can be reasonably expected that they would say so. I move on to the legal context against which plausibility must be assessed. As a first point, it was said repeatedly yesterday that Russia's position is that because there is an ongoing armed conflict, the ICSFT is inapplicable. For example, Professor Coe portrayed me as saying in the first round that in times of armed conflict, IHL is the sole body of law that prohibits the spread of terror among the civilian population. Well, you can see from the extract up on the screen that I said nothing of the sort, but was merely making the point that the OHCHR and the ICRC will be looking at the conflict through the prism of IHL. There was a similar mischaracterization of our argument by Mazmani Cheek. I took the court to Article 21B and Article 21 ICSFT to make the point that the ICSFT offence of terrorism uses language that is materially different to Article 51.2 AP1 and Article 13.2 AP2. Not, of course, to say that the ICSFT could not apply where IHL provisions also applied. Russia has taken no point as to the potential applicability of the ICSFT in an armed conflict, and it is telling that Ukraine should be using its limited time to mischaracterize what has been said instead of seeking to challenge the points that were actually being made. This brings me to Article 2.1 of the Convention, where there was some discussion yesterday as to the specific language, but I think it was ultimately accepted that the language of Article 2.1 is materially different to, and in certain respects, more stringent than Article 51.2 AP1 and Article 13.2 of AP2, so far as requiring intent to cause death or serious bodily injury to a civilian, and separately that the purpose must be to intimidate a population or to compel a government or an international organization to do or abstain from doing any act. Ms. Marnie Cheek did, however, repeatedly refer to Article 2.1 as requiring a purpose, which did not fit well with her position that the focus should be on the plain language of the Convention. In fact, Ms. Marnie Cheek did not refer to the plain language of Article 2.1 at all, but sought to introduce different sources of law, seemingly in an attempt to water down the specific definition of a terrorist act under Article 2.1 ICSFT. Particular attention was paid by her to a contention that intent includes recklessness. But the existence of specific intent to cause death or serious bodily injury to civilians is only the first of the two independent limbs of the definition of a terrorist act under Article 2.1 ICSFT. And you heard little or nothing yesterday about the second crucial requirement in relation to the specific purpose of the alleged act. For example, you were taken to the definition of intent in the Rome Statute, but that hardly assists Ukraine. The Rome Statute has no relevance at all to the specific purpose requirement for terrorism. The Rome Statute makes no reference to terror, as there was a deliberate decision to exclude terror offences from the jurisdiction of the ICC. So the Rome Statute is in no sense an obvious place to look, as you were told quite inaccurately yesterday. Let me deal with Galich, which was said to be instructive and said to concern a campaign of artillery and mortar shelling onto civilian areas, I quote, not unlike what Ukraine has experienced. That is a very problematic statement, and it suggests that Ukraine has no wish to put a fair picture of the events on which it relies before you. Galich, of course, concerned the siege of Sarajevo. The sniping and shelling at issue in Galich went on for 44 months, according to the indictment. It concerned a relentless campaign comprising many thousands of individual acts of shelling and sniping, against civilians everywhere within one city, as, for example, one sees from paragraph 584 of the trial chamber judgment. All residents of ABIH-held areas of Sarajevo who appeared before this trial chamber testified to the effect that no civilian activity and no areas of Sarajevo held by the ABIH seemed to be safe from sniping or shelling attacks from SRK-held territory. The majority heard reliable evidence that civilians were targeted during funerals, in ambulances, in hospitals, on trams, on buses, when driving or cycling, at home, while tending gardens or fires or clearing rubbish in the city. The most populated areas of Sarajevo seemed to be particularly subject to indiscriminate or random shelling attacks. Hadji testified about every single part of Dobrinja, a very populated neighborhood exposed to severe shelling originating from SRK-controlled territory. So 2 points. First, this, one must thankfully say, is quite unlike what Ukraine has experienced. Ukraine has pointed to 4 isolated events of allegedly indiscriminate shelling at Mariupol, Kramatorsk, Volnovarka, and Avdiivka, at all of which there does appear to have been a military target. And I'll come back to that shortly. Secondly, the passages of the trial chamber and appeal chamber judgments that Mazmani Cheek took you to yesterday did not concern indiscriminate acts and the spread of terror, but rather the quite separate offences with respect to direct attacks on civilians. Thus, at paragraph 132 of the appeal chamber judgment, to which Mazmani Cheek referred, the appeal chamber said, in principle, the trial chamber was entitled to determine on a case-by-case basis that the indiscriminate character of an attack can assist it in determining whether the attack was directed against the civilian population. Of course, separately from the spread of terror, IHL prohibits willfully making the civilian population or individual civilians the object of attack. That is Article 85 of AP1. And it was in this quite different context that the appeal chamber, agreeing with the trial chamber, found that the notion of wrongful intent encompasses recklessness. There is, however, no reference to recklessness in the passage of the judgments addressing the distinct offence of spreading terror. So, what is happening here is that you're being taken to the parts of Galich which at best could be relevant only to the first part of Article 2.1, intent to cause death or civilian injury to a civilian. As to the reference to indiscriminate attacks in the context of the appeal chamber's consideration of the offences in relation to terror, you are not taken to this, presumably because the appeal chamber stresses the primary concern is that those acts or threats of violence be committed with the specific intent to spread terror among the civilian population. There is no suggestion that recklessness would suffice with respect to that specific intent. And of course, this is exactly what you'd expect. If recklessness was sufficient with respect to the intent to kill and injure civilians, and likewise with respect to the purpose of spreading terror, then the separate prohibition of indiscriminate shelling would simply start to transmute into the specific prohibition of the spread of terror. Thus, and this is why we referred to Galich and Dragomir Milosevic in the first round, the ICTY cases demonstrate how the legally separate prohibitions of indiscriminate shelling and spreading terror are not to be conflated. Another useful ICTY case for the specific purpose of provisional measures is Gotovina. This concerned a massive artillery assault on Knin and artillery fire directed on civilian targets in various other towns and villages by the Croatian armed forces in August 1995. While Gotovina was indicted for the offence of persecution on political, racial and religious grounds, as well as various other offences, the prosecutor did not include a charge of spreading terror. This is of obvious importance for today's purposes, as the test applied by the ICTY prosecutor for indictment is close to that of plausibility. Pursuant to Rule 47B of the ICTY Rules of Procedure and Evidence, the test for an indictment is whether there is sufficient evidence to provide reasonable grounds for believing that a suspect has committed a crime within the jurisdiction of the tribunal. It follows from the prosecutor's decision not to invite Gotovina for the offence of spreading terror that the acts of indiscriminate shelling, which appear to have been far more extensive than anything Ukraine has referred you to, were not considered to amount to terrorist acts, not even to the extent of there being sufficient evidence to provide reasonable grounds for believing so. And as the court has recently confirmed in the Croatian genocide case, the fact that certain acts were not prosecuted before the ICTY as a specific crime is of particular legal significance. As to the decision of the Italian Supreme Court of Cassation in Abdelaziz, the question there was whether the accused was right to claim that in a situation of armed conflict, so-called kamikaze suicide actions, when committed against military objectives, cannot be regarded as terrorism, even if causing serious damage and spreading fear among the civilian population. The context is quite different, and it is anyway not Russia's case that the mere presence of a military objective is always determinative of the question whether a given attack may amount to a terrorist act. For example, the existence of certain military objectives in Sarajevo did not preclude the relentless shelling campaign from constituting an act of terror. The Article 2.1b question is, was there the requisite intent to kill or harm civilians for the purpose of intimidation or compulsion? There is, however, a real issue with the reasoning of the Italian court in this respect. As to the second important limb of the test, that is purpose, the court said, an act against a military objective must also be regarded as terrorism if the particular circumstances show beyond any doubt that harm to the life and physical well-being of the civilian population are inevitable, creating fear and panic amongst the local people. That reasoning does not take into account the entirety of Article 2.1b, and it's also inconsistent with the widely accepted proposition that the fear among civilians, which naturally occurs during armed hostilities, must be distinguished from spreading terror. As the trial chamber explained in Milosevic, the trial chamber also notes that the crime of terror only covers acts or threats of violence which are specifically intended to spread terror among the civilian population. It must be established that the terror goes beyond the fear that is only the accompanying effect of the activities of armed forces in armed conflict. The trial chamber notes that a certain degree of fear and intimidation among the civilian population is present in nearly every armed conflict. The closer the theatre of war is to the civilian population, the more it will suffer from fear and intimidation. This is particularly the case in an armed conflict conducted in an urban environment, where even legitimate attacks against combatants may result in intense fear and intimidation among the civilian population. But to constitute terror, an intent to instill fear beyond this level is required. As I explained on Tuesday, and will return to shortly, in each of the 4 isolated incidents of alleged indiscriminate shelling at Mariupol, Volnovarka, Kramatorsk, and now Avdiivka, there appears to have been some form of military objective. The existence of such military objectives is a pertinent factor in assessing whether Ukraine has demonstrated, as it must, a plausible case of specific intent and specific purpose, as is required by Article 2.1 ICSFT. And this is all the more so since Ukraine's case is that both of those requirements must be inferred from the allegedly indiscriminate nature of the shelling. As to this, the court will recall its general approach that where there is no direct proof that prohibited acts have taken place with the required subjective element in order to infer such intention from a pattern of conduct, it is necessary that that is the only inference that could reasonably be drawn. Reference was also made by Mazmani Cheek to a passage from the decision of the Special Tribunal for Lebanon in Ayash. This was said to confirm that the ICSFT is not more stringent, but simply different, in that IHL is not concerned with a prohibition on the financing of terrorism. Well, it's very difficult to see what that point adds, as it's manifest from the very wording of Article 2.1 and indeed the Convention's title, that it is concerned with financing. I turn once more to the individual events that are relied upon to show a plausible case on breach of Article 2.1. First, Volnovarka and Mariupol. Mazmani Cheek did not engage with the point that I was making, which was that the bus at Volnovarka was struck while stopped at a Ukrainian army checkpoint. You see the OSCE statement on the screen. And that, regrettably, all parties, including Ukraine, appeared to be treating military checkpoints as targets. She speculated that such an attack could be part of a campaign to obtain political concessions, but not a single document, whether from the OHCHR, the OSCE, or indeed any Ukrainian or other news source or any other source, was relied on as support. As I understood it, the same speculation was being made with respect to the events at Mariupol. No mention was made of the fact that the OSCE considered it appropriate in its spot report to record twice that the incident took place approximately 400 meters from a Ukrainian armed forces checkpoint. Instead, reference was made to a statement by the UN Under-Secretary General for Political Affairs to the effect that Mariupol was a targeted attack. He did not, however, suggest that there had been an act of terrorism, and of course the Secretary General himself had characterized the event as indiscriminate shelling. Secondly, Kramatorsk, where it is said that I was mistaken to say that the shelling incident was 200 to 300 meters away from a Ukrainian military compound in Lenin Street. Well, here is what the OSCE spot report to which I was referring says. On 10th February at 11:51, the SMM heard a powerful explosion in Kramatorsk. From their position at Kramatorsk Boulevard number 41, the SMM assessed that the sound of the explosion came from approximately 1.5 kilometers southeast, near Kramatorsk Airport, where the Ukrainian authorities have deployed an anti-terrorist operation base. And this is the base to which Mizmani Cheek referred. And there is then a reference in the Spot report to blasts around Kramatorsk Boulevard. But you see then that the report continues to deal with Lenin Street, where the SMM spotted a second set of unexploded ordnance, which landed behind the house on the yard side. Reference to the site located 2.5 kilometers northeast of Kramatorsk Boulevard, number 50. And then at 12:45, at the entrance of a Ukrainian military compound on Lenin Street, the SMM saw a member of uniformed Ukrainian armed forces personnel lying on the ground, not moving. My reference to 200 to 300 meters from a Ukrainian military compound was, as was plain from what I was saying, made by reference to shelling at or near Lenin Street. It may suit Ukraine to focus only on the Ukrainian military base at the airport, not the Ukrainian military compound within the city, but its existence cannot just be ignored. I turn to the recent events of Avdiivka. The point I was making on Tuesday, and to which there was no answer yesterday, was that the order of events was as follows. 1, Ukraine moves tanks to residential areas in Avdiivka in breach of the agreed withdrawal lines. 2, there is then shelling of those areas in Avdiivka by DPR, LPR armed groups. Professor Coe said it was ironic that Russia was focusing on photographs showing Russian tanks defending the city. That was studiously to ignore the chronology of events as it appears from the OSCE reports and the BBC, and to ignore Ukraine's violations of the withdrawal lines to which the OSCE repeatedly refers. The situation at Avdiivka was portrayed as one of great urgency yesterday. Curiously, you weren't in fact shown the current picture. But as of early February, when these events occurred, the urgent action needed was that Ukraine should remove its armed forces from residential areas in Avdiivka. All Mizmani Cheek had to say was that the BBC video footage that we showed you was not properly on the record. That is not a good point. The first Russia knew of Ukraine's reliance on events at Avdiivka was Monday's hearing, and it was responding accordingly in trying to put reliable evidence of the facts before you, in particular of the relevant chronology, from the OSCE and the BBC. It is regrettable but telling that Ukraine should seek to discourage you from looking at that evidence. I wish to come back to Resolution 2202 and its endorsement of the amnesty and pardon in the Minsk package of measures. These are of obvious importance so far as concerns whether the events of indiscriminate shelling on which Ukraine relies can plausibly be characterized as terrorism. The only person to address this was Professor Coe, who said, Ukraine did not agree to such an amnesty which excluded grave breaches. Certainly no amnesty agreement was ever intended to foreclose prosecution for the perpetrators of the MH17 shootdown or other heinous terrorist acts. 3 points to make. First, I referred to Resolution 2202 only in the context of Ukraine's case that alleged acts of indiscriminate shelling, including at Kramatorsk, Volnovarka, and Mariupol, are to be equated with terrorism. Those events preceded Resolution 2202 and it is self-evident that all would have them in mind. I did not refer to Resolution 2202 in the context of Flight MH17, to which it is not relevant. In this respect, the preamble of Resolution 2202 expressly reaffirms Resolution 2166, which demanded that those responsible for the shooting down of MH17 be held to account. Consistent with this, it is plain from the meeting record that MH17 was not intended to be caught by Resolution 2202. This is what was said, for example, by the UK representative. The resolution we have adopted today reaffirms Resolution 2166 on the downing of Malaysia Airlines flight MH17, in which the Council demanded that those responsible be held to account and that all states cooperate with the efforts to establish accountability. Let me be clear that the amnesty provided for in the Minsk package does not apply to those who may be found responsible for that dreadful crime. And this leads to the second point. This is all that was said. There was no suggestion that anything else was to be excluded from the scope of the resolution, and that is the critical point. It is indeed inconceivable that there would be Security Council endorsement for an amnesty in respect of alleged indiscriminate shelling that had taken in the months immediately prior to this resolution, in fact in the weeks immediately prior to this resolution, at Kramatorsk, Volnovarka and Mariupol, and also similar acts for which Ukraine's armed forces were allegedly responsible, such as the shelling at Kaprina Street in Donetsk, if these had been or could plausibly be regarded as terrorism. Third point. Professor Coe asserted that Ukraine did not agree to such an amnesty. But that is not supported by any evidence, whether by means of a statement by Ukraine at the time that the Minsk package of measures was agreed, or by a statement before the Security Council. The package of measures says what it says. It was agreed to by Ukraine. It cannot now be recast to suit the confines of the way Ukraine now wishes to present its legal claims before you. The simple point is that the Minsk package of measures and the Security Council's endorsement confirm the conclusion that can safely be drawn from a closer look at the alleged acts of indiscriminate shelling now said to constitute terrorism by Ukraine alone, that there is no plausible case of terrorism before you. There was an attempt by Professor Coe to say that the big point was that it is said by Ukraine, there is said to be evidence that that Russia has supplied weaponry to the DPR and the LPR. And that leads to 2 points. First, Russia contests this and also points to the unreliability of Ukraine's evidence. The Honourable Agent for Russia will return to this briefly a little later. Secondly, Professor Coe neglected to address the critical point for this hearing. As we said in the first round, wholly non-specific evidence on supply of weaponry in an ongoing armed conflict cannot assist the court because it does not begin to engage with the Article 2 requirement that funds be supplied with the knowledge or intent that they are to be used for specifically terrorist acts. I turn then to that issue of knowledge or intent, as to which Ukraine must also make a plausible showing. Here, you are asked to engage in an exercise of joining a series of supposed dots. You're shown a document said to show the supply of funds to the DPR or LPR, and you're asked to infer that the funds are provided with the knowledge or intent that they will be used in full or in part for a terrorist act. For example, you were shown on the screen on Monday a letter from the head of the LPR to Russian MP Sergei Mironov, thanking the latter for assistance, and this was put forward as evidence of the funding of terrorism. The only basis for that could be Ukraine's unsupported assertion that the LPR engages in acts of terror, made on the basis that the LPR has allegedly engaged in acts of indiscriminate shelling, acts for which Ukraine itself is at least as equally responsible on the basis of its own evidence. There was reference yesterday to the, quotes, very strong evidence put forward that Russia knew the types of activities the DPR and similar groups would engage in, with the support being provided. But once again, the only document cited in support was the OHCHR report of 15th June 2014. But that solitary document concerns underlying allegations that form no part of Ukraine's request and no part of its specific allegations of breach of the ICSFT at Section 4 of its application. The passage relied on concerns abductions and detentions. It has nothing to do with indiscriminate shelling or any other form of alleged terrorist activity in the request. How then was it to provide a basis for knowledge of terrorist intent with respect to the acts that are the subject matter of the request, and that, moreover, were agreed by Ukraine to be the subject of a pardon and amnesty as endorsed by the Security Council? Indeed, Ukraine is not even troubled to answer the obvious question as to how alleged abduction or detention fits within the killing or serious bodily injury requirement that defines the scope of application of Article 2.1b of the Convention. As to Kharkiv, there was no comeback on my point as to the flimsy evidentiary basis for alleged financing by Russia or by Russian nationals with the requisite knowledge. Moreover, the bombing of 22nd February 2015 was raised by Ukraine in diplomatic correspondence only on 15th September 2015. Russia subsequently confirmed its interest in receiving from the Ukrainian party the concrete materials containing evidential data in support of the declarations made. Although the matter was discussed by the parties during the third round of negotiations, Ukraine failed to provide any additional information. I turn to the allegation that Russia provided the weaponry used to shoot down flight MH17, with the knowledge that this weaponry would be used for a terrorist act. There are 3 points that I wish to make. First, Professor Coe floated the possibility of an entirely new Ukrainian case with respect to flight MH17. He said, if Russia knows of particular individuals within its territory who, for example, aided the movement of the Buk missile launcher into Ukraine and back to Russia again after the MH17, which you saw with your own eyes, Russia has obligations to investigate and prosecute them under various provisions of the Convention. But Ukraine's case, as set out in the clearest of terms in its application, its request, and on Monday morning, is that Russia itself financed the shooting down of flight MH17. And this is a telling attempt to reformulate the claim on the hoof, following our response on Tuesday to Ukraine's allegations. If Ukraine wishes to make different allegations of breach with respect to Article 2.1 of the Convention, it will have to tell Russia what those allegations are before Russia can respond. Secondly, Ms. Marni-Cheek elected to focus the greater part of her argument on the question of whether the shooting down of MH17 could plausibly be an act of intentional destruction of a civilian aircraft within the Montreal Convention. But that is to address an argument that I did not make. Thirdly, as to the point I did make, which was that there is no evidentiary basis whatsoever for the deeply serious allegation that Russia supplied the alleged weapon with the requisite knowledge or intent, there was no answer at all. I invite the Court to read with great care the transcript of Ms. Marni-Cheek's section on knowledge at pages 43 to 44 of yesterday's transcript. There is no mention of flight MH17. There is no mention of page 5 of the JIT presentation of September 2016, or of the JIT video that Russia lodged with the court on Tuesday, both of which, as I said in the first round, make it quite plain that if the JIT evidence were to be relied upon, it shows that whoever was allegedly supplying the Buck launcher was acting solely in response to and for the purposes of defending against a series of armed attacks by Ukraine's military air force. How and why, one wonders, can such a serious allegation be put before this court on day one, as if it were the very centerpiece of the case? And then, by the time of the second round, there is not a word said in response to the points on the key requirement of knowledge that the opposing counsel has actually made. In any event, it's not just that there is no plausible case in relation to breach by Russia with respect to the tragic shooting down of flight MH17. If account is to be taken of the entirety of the JIT material on which Ukraine relies, which must be taken as containing Ukraine's factual allegations, the court also lacks jurisdiction prima facie. On that basis, the facts, even as alleged by Ukraine, do not fall within the Convention. I move to the absence of a plausible case on breach of Article 18, as to which there was, again, no response at all to the point I made on Tuesday. That is, that Russia is being alleged to engage in a bad faith charade on cooperation, whilst there is no evidence to support that. The only specific complaint made was as follows. As to MLAT requests, however, I would note that Mr. Rogachev insisted that the Russian Federation has executed on 69 of 79 Ukrainian MLAT requests in criminal proceedings related to acts of terrorism. Ukraine has submitted 51 requests, 18 of which were responded to in a reasonable time. We do not know where Russia gets its figures. And this is notably cautious wording. It's not said how many MLAs have been executed by Russia, or indeed, there is no reference to the number to which Ukraine has received a response. Rather, the complaint appears to have distilled down to the issue of whether responses have been received in what Ukraine considers to be, without any details of any kind, a, quotes, reasonable time. Mr. President, members of the Court, I thank you for your kind attention, and I ask you to call Professor Zimmerman to continue Russia's submissions on the ICS-FT.
Merci. Je donne à présent la parole à Monsieur le professeur Zimmerman.
Merci, Monsieur le Président. Monsieur le Président, membres de la Cour. Following up on Mr. Wordsworth, I will now return to the issue of the Court's prima facie jurisdiction under Article 24 ICSFT. I will, in particular, deal with Ukraine's arguments as to the scope of the ICSFT, and namely the issue whether it covers matters of state responsibility of a state itself purportedly providing funds for alleged acts of terrorism. Let me once again reiterate that this issue, and that obviously includes the applicability of Article 18 ICSFT, only arises provided acts of terrorism, as narrowly defined in Article 2 of the Convention, have occurred, and further provided that funds were provided either with the intention or with the knowledge that they are to be used to carry out specific terrorist acts. But let me now start with the issue of the fulfillment of the formal, still not less important requirements of negotiations laid down in Article 24 ICSFT, namely the obligation to try to set up an arbitral tribunal. I note first in this regard that the reference made by Counsel for Ukraine yesterday to the provisional measures phase of Belgium versus Senegal is misleading. In that case, as the Court is aware, Belgium had submitted a proposal for arbitration as required by the applicable compromissory clause, while the other party simply did not react. It was in these peculiar circumstances that the Court stated that any specific proposal is only required once a response had been given, and indeed, how could it be otherwise? But that's not the situation at hand, given that the party had already been in quite close contact on the matter. Indeed, as the Court has confirmed in Congo versus Rwanda, the, quote, existence of such disagreement on the setup of an arbitration can follow only from a proposal for arbitration by the applicant, to which the respondent has made no answer or which it has expressed its intention not to accept, end quote. Instead, in our case, it was, as I've previously noted, the Russian Federation that, once the negotiations on a possible arbitration had started, submitted very concrete and broad text proposals as to both the envisaged arbitration agreement and possible rules of procedure. And this brings me back to Ukraine's proposal to immediately bring the case before the Court, rather before an arbitral tribunal by way of the creation of an ad hoc chamber of the Court, be it only to thereby allegedly fulfilling the requirement laid down in Article 24 ICSFT that there must be a disagreement about the, quote, organization of the arbitration. Counsel for Ukraine tried to rely for that purpose on statements by a long-time former member of the bench, Judge Oda, which statements, I'm afraid to say, he entirely misconstrued. Judge Oda had characterized, and rightly so, I might say, an ad hoc chamber as, quote, essentially an arbitral tribunal, end quote, simply in order to stress the influence parties to a case have under Article 17, paragraph 2 of the Rules of the Court when it comes to the composition of the respective chamber. And this is brought out by Judge Oda himself when stating, and I now quote again Judge Oda, that, quote, parties in dispute can choose either an ad hoc chamber or an arbitration, either or. That is what Judge Oda said, end quote. And that stands in line with the statement by the then president of the ad hoc chamber in Gulf of Maine, who unequivocally confirmed that, quote, la chambre et la cour, end quote. This fact is further made abundantly clear by Article 27 of the Court statute, and accordingly such chamber cannot be regarded as an arbitral tribunal within the meaning of Article 24 of the compromissory clause in this case. Thus, in essence, Ukraine never engaged in negotiations about the organization of an arbitration when it referred to seizing this court by setting up an ad hoc chamber of this court. Russia, in turn, had expressly pointed Ukraine to the fact that Ukraine's insistence on this point and I quote from a Russian diplomatic note, quote, would undermine the very nature of the negotiations, which would not be regarded as negotiations on the organization of arbitration, and the request of the Ukrainian side to submit the dispute for arbitration would not be regarded as such within the meaning of Article 24 of the ICSFT ab initio, end quote. But that was to no avail. But Ukraine tells you that all this does not matter anyhow, because there is, it claims, no requirement of a bona fide attempt to negotiate in that regard. As Ukraine's counsel implied, it simply suffices to let the clock tick. If that were true, that would truly empty Article 24 ICSFT of all of its very content and purpose. Let me also note in passing that Ukraine had nothing to say about the issue of the proposed enforcement of a future arbitral award by the Security Council, nor about its proposal to do so at variance with the voting requirements prescribed by the Charter, which enforcement mechanism Ukraine had also considered to constitute one of its mandatory core principles on which the parties had to agree, it claimed. Let me now move on to the scope of the ICSFT and its interpretation, especially as far as the notion of state-sponsored terrorism is concerned, before then addressing in more detail Article 18 ICSFT. Mr. President, before doing so, I believe it is in order to first clarify some matters of terminology, given that it seems that there might have been some confusion as to the notion of state responsibility, which is, or rather is not, covered by the ICSFT. In doing so, one has to obviously determine first what are, to use the ILC's terminology on the matter, the primary rules contained in the ICSFT. For one, and it seems there is consensus between the parties on that, matters of a state allegedly committing itself acts of terrorism are beyond the scope of the ICSFT. The Russian Federation additionally submits that the obligation to not finance alleged terrorist acts, when such financing is provided by a state, and accordingly by its organs, does not form part of the primary obligations contained in the ICSFT. And I believe we have by now submitted ample evidence for such proposition, and I will adduce more in the minutes to come. Accordingly, any act by a person, the acts of which are attributable to a state under regular rules of state responsibility do, in Russia's view, not constitute treaty violations under the ICSFT. Accordingly, a state does not incur responsibility under the ICSFT for such acts either. To state the obvious, this does not mean, however, that a state may not incur responsibility for such acts as constituting violations of customary international law, and namely, possibly, for violations of the principle of non-intervention. But that is, as the Court has confirmed time and again, a completely separate matter. Mr. President, as you will recall, it was during my first round speech 2 days ago that I've already referred to Articles 4, 5, and 24 ICSFT in particular, as well as to the ICSFT's drafting history, to demonstrate that the ICSFT does not cover issues of state responsibility for a state itself allegedly financing acts of terrorism. I've also shown that this result is, besides, confirmed by a comparison of Article 24 ICSFT with Article 9 Genocide Convention, by the ongoing negotiation process on a comprehensive convention on terrorism, as well as by subsequent state practice implementing the ICSFT, to which I will return in more detail soon. Let me first note that Ukraine has deliberately decided not to engage with some of these questions, and certainly has not engaged with the very wording and the drafting history of Article 5 ICSFT, nor indeed with the matter of subsequent state practice. Mr. President, Ukraine has done so, I assume, because for Ukraine at least, the case is very simple and straightforward, almost banal it seems. And that is why, in its view, no legal gymnastics of whatever kind is required. Let me apologize already at this stage that maybe things are not so easy as they were portrayed, and that therefore I might have to take you through some more of such legal gymnastics, namely by engaging in treaty interpretation as laid out in your own jurisprudence. As Ukraine puts it, those 187 states that have so far acceded to what Professor Coe referred to as, quote, the comprehensive, quote, terrorism financing convention, end quote, have thereby simply accepted Ukraine's interpretation of the ICSFT. Accordingly, each and every one of those 187 states that would provide material support to a non-state actor involved in a non-international armed conflict where the insurgents then commit violations of IHL, such as indiscriminate shellings, would be subject to the court's compulsory jurisdiction under Article 24 ICSFT and be subject of a determination of being a state sponsor of terrorism. But why be concerned, tells Professor Coe the court. There is no need to worry since states have freely accepted such treaty-based obligation. Professor Coe, at the same time, was, however, so kind to also remind all of us of your Nicaragua versus US judgment, be it only for some other reason. In Nicaragua, the court obviously found not only that insurgents involved in an armed conflict, the Contras, had been financially supported by the United States. The court also found in Nicaragua that those armed groups had committed serious violations of Common Article 3 of the 4 Geneva Conventions, which certainly, in Ukraine's reading of the ICSFT, would amount to acts of terror within the meaning of Article 2, Paragraph 1, Litera B, ICSFT. In Ukraine's view, therefore, such Nicaragua type of situation, if it were to occur today, would then be an almost clear-cut case to be brought before you under Article 24 ICSFT, without the need for the court anymore to either rely on Article 36, Paragraph 2 declarations, nor to rely on any kind of a bilateral treaty in order to be able to exercise jurisdiction. Thus, according to Ukraine, those 187 states that have ratified the ICSFT, except for those few that made reservations to Article 24 ICSFT, have thereby accepted your jurisdiction on such matters, and have allegedly thus also accepted to be subject to the possibility of provisional measures, provided there's a plausible case on such facts. Is such an interpretation of the ICSFT truly plausible? Is that the broad content of the ICSFT agreed after lengthy and very controversial negotiations? Mr. President, let me remind you, as I've already demonstrated 2 days ago, of the fact that the very issue of the inclusion of the concept of state-sponsored terrorism continues to constitute the stumbling block as far as the ongoing negotiations on a possible future comprehensive convention on terrorism are concerned. But Ukraine, once again, has a simple answer to that. States should not be concerned, since, in any case, that very issue has already been decided, given that states have already accepted such concept, including the court's jurisdiction on the matter, when they ratified, as Professor Coe put it, quote, the Comprehensive Terrorism Financing Convention, end quote. I'm simply wondering, quite frankly, what legal advisors currently participating in the negotiating process as members of the General Assembly's Sixth Committee would make out of such, as Ukraine puts it, plain proposition. It's against this general background that I will now show that the limited interpretation of the ICSFT, as I've submitted it, is fully in line with the very object and purpose of the ICSFT. Ukraine has claimed that the ICSFT's object and purpose would be defeated were it not to cover issues of state responsibility for financing acts of terrorism. This broad and largely unsubstantiated claim is, however, contradicted by a careful analysis of the very text of the ICSFT. Let me once again starting by considering the text of the Convention, starting with its very preamble. As confirmed in the Court's jurisprudence, the object and purpose of a given treaty is not the least brought out by the preamble of a given treaty. Yet, the preamble of the ICSFT confirms that the said convention was concluded with the view to provide for, quote, the suppression of terrorism through the prosecution and punishment of its perpetrators, end quote. This stated goal of the convention, being indicative of the ICSFT's object and purpose, therefore inherently focuses on individual criminal responsibility rather than embracing the concept of state responsibility. Besides, the preamble of the ICSFT also refers to the need to, quote, enhance international cooperation among states. Hence, the perceived aim is to have states cooperating in combating acts of terrorism, which one again presupposes that such acts of financing terror covered by the ICSFT are committed by private individuals. And let me now move on to the very title of the Convention. And let me start with a brief observation. Ukraine, throughout its pleadings, has referred to the ICSFT as, quote, the Terrorism Financing Convention. This is both telling as well as misleading in itself. Obviously, the narrow title of the ICSFT, namely the International Convention for the Suppression of the Financing of Terrorism, constitutes the, quote, obvious starting point for identifying the ambit of the treaty, end quote. What is more is that the very purpose of a treaty, as you have confirmed most recently in your latest judgment in the maritime delimitation in the Indian Ocean case, Somalia versus Kenya, quote, may be indicated by its title, end quote. As a matter of fact, as already the Beagle Channel Award had confirmed, such title delimits, quote, the intention of the treaty as a whole, end quote. Obviously, therefore, given its title, the purpose of the ICSFT is not, contrary to what Ukraine tries to imply, to cover the financing of terrorism tout court. Rather, the treaty obliges states to merely suppress the financing of terrorism. That very wording, suppression of the financing, la répression du financement du terrorisme, in turn presupposes that the ambit of the ICSFT relates to situations where individuals or another entity distinct from the contracting party and its organs is engaged in the financing of terrorism, which acts of private financing the contracting parties of the ICSFT are then supposed to suppress. E contrario, this also means that acts by a contracting party itself or by any of its organs or entities for which it bears state responsibility under general international law do not come within the ambit of the ICSFT. This limited understanding of the ICSFT's object and purpose, which is brought out already by its own very title, is further confirmed by a comparison of the very restrictive title of the ICSFT with other similar treaty titles, the relevance of such a comparison having been confirmed by the Court in its judgment on preliminary objections in the All Platforms case. As a matter of fact, the title of the European Convention on the Suppression of Terrorism could indicate that this treaty was meant to be broader in nature than the ICSFT, given that its title relates generally to the suppression of terrorism, rather than merely to the suppression of its financing, like the ICSFT does. Yet, even the European Convention on the Suppression of Terrorism does not cover alleged acts of terrorism for which a contracting party bears international responsibility. Rather, just like the ICSFT, it merely provides for the obligation to counter acts committed by private actors only. And the same holds true for the Inter-American Convention Against Terrorism, which, despite its even broader title, Inter-American Convention Against Terrorism, again merely relates to and entails obligations to penalize and prevent terrorist activities by private actors, such acts not being attributable to the respective state party. Mr. President, is it then really plausible to argue that the object and purpose of the ICSFT, as well as its scope, was meant to extend far beyond the one of the European Convention, and far beyond that of the Inter-American Convention, to also cover acts of state financing alleged acts of terrorism. And that this were the case, despite the fact that already the ICSFT's title is significantly more limited in scope. And, Mr. President, I assume that this also puts to rest the claim made by Professor Coe as to the alleged, quote, sweeping title, end quote, of the ICSFT. And that immediately brings me to my next point, to the point made by Ms. Cheek yesterday, namely, as she then put it, that, quote, negotiating states know how to exclude a state activities from a treaty's scope, end quote. Ukraine's argument goes that had states truly wanted to exclude matters of state responsibility from the realm of the ICSFT, they would have provided for a specific clause saying so. But that argument, as our colleagues representing Ukraine would probably put it, is a red herring. The issue is not whether states wanted to allegedly exclude state activities from the scope of the ICSFT, but rather whether they wanted to include acts by states into the scope of the ICSFT at the first place. And it is this latter question that has to be answered, and has to be answered by applying regular rules of treaty interpretation. And obviously, a treaty's drafting history forms an important part of it, in particular in such a sensitive area of international law with which I've already dealt with quite extensively, but which, again, Ukraine only addressed on the margins, if at all. For the sake of completeness, I will, however, now deal with one instance where Ukraine did engage with the ICSFT's travaux préparatoires. Yesterday, Ms. Cheek referred you to a statement by the French delegation according to which the future convention was meant to cover, quote, all forms of financing, including private and public financing, end quote. Unfortunately, however, an incomplete picture was presented to the court about that part of the ICSFT's drafting history. Indeed, France had initially proposed to define financing in what is now Article 1, Paragraph 2 ICSFT as any contribution, be they, quote, public or private. And that was the point made by Ms. Cheek yesterday to confirm her claim that state funding of alleged terrorist acts are indeed covered by the ICSFT. And she would be right, provided this proposal had been retained. Yet, it suffices to note that, as you can simply by reading Article 1 of the ICSFT as adopted, that the reference to public contributions, public financing, was not retained. And that deletion of any reference to public funding has to be seen in the context of the parallel deletion of the French draft Article 5, Paragraph 5. As you will recall from my first round speech, draft Article 5, Paragraph 5, if also retained, would have also provided for a savings clause on matters of state responsibility. Yet, just like the reference to public financing in what is now Article 1 ICSFT, draft Article 5, Paragraph 5 was also deleted because, whether we like it or not, matters of state responsibility were considered not to be appropriately addressed by the future ICSFT. Before moving on to subsequent state practice, let me now say some additional words on the judgment of the Special Tribunal on Lebanon, STL, in the Ayesa case to which Ms. Cheek has referred. Obviously, Mr. Wordsworth has already shown its limited relevance, if at all. However, and in any way, it is also the STL's understanding that the ICSFT constitutes exclusively a criminal law enforcement instrument. For one, the STL stated that the ICSFT, quote, is a veritable litmus test for the attitude of states towards criminalizing terrorism, end quote, rather than an issue of a state themselves purportedly supporting alleged terrorist acts. In the view of the STL's appeals chamber, the ICSFT regulates criminal responsibility by governing, quote, activities that otherwise would go unpunished either by criminal law or by IHL, end quote, but therefore does not govern matters of state responsibility, even when seen from the perspective of the STL. Let me now come back in somewhat more detail to the question how states perceive the content of the ICSFT when submitting this treaty for approval by their national parliaments, to which I had already briefly alluded to during my first round of oral pleadings. Mr. President, the limited understanding of the scope of the ICSFT, which is already, as been shown by the result of a careful and in-depth analysis of the Convention's very text and its drafting history, rather than being based on broad assumptions what the content of the ICSFT ought to be, is further confirmed by the practice of states submitting the Convention for ratification by their parliaments. And I will limit myself, for lack of time, to provide you with some examples only, but I can assure you there are plenty more. When submitting the Convention to their respective parliaments, states describe the ICSFT's object and purpose as obliging states parties to criminalize the private financing of terrorism, to undertake acts to prevent such private funding, and to cooperate with other states parties according to the concept of audedere et judicare. Australia, which may serve as an example for a number of other states, noted in that regard that the ICSFT, quote, obliging state parties to criminalize the collection of funds for the purpose of committing terrorist acts and to cooperate with other state parties in the prevention, detection, investigation, and prosecution of terrorist financing, end quote. In the same vein, the United States government understood the ICSFT to, quote, require states parties to criminalize under their domestic laws certain type of criminal offenses, and also requires parties to extradite or submit for prosecution persons accused of committing or aiding in the commission of such offenses, end quote. And again, in the same vein, the British government merely proposed a set of changes to its domestic criminal law, thereby, quote, enabling the UK to meet its obligations under the provisions of those suppression of terrorism conventions which are common to earlier international counter-terrorism conventions, end quote. Finally, Switzerland similarly understood the ICSFT to exclusively being an instrument to counter private criminal acts. As stated in the official document submitting the ICSFT for ratification, and I quote, les États doivent ériger les infractions couvertes par cette convention. En outre, la convention institue un système cohérent et complet de coopération internationale régissant les domaines de l'extradition, de l'entraide judiciaire et du transfèrement de personnes condamnées. End quote. What is brought out by these examples is that states implementing the ICSFT perceived it as a criminal law instrument addressing individual behavior but not one governing state action vis-à-vis other states. And that indeed is also how the International Monetary Fund sees the ICSFT when stating in its guide on the implementation of the ICSFT that, and I quote from the IMF, the Convention contains 3 obligations for state parties. First, states parties must establish the offense of financing of terrorist acts in their criminal legislation. Second, they must engage in wide-ranging cooperation with other states parties and provide them with legal assistance in the matters covered by the Convention. Third, they must enact certain requirements concerning the role of financial institutions in the detection and reporting of evidence of financing of terrorist acts, end quote. And that now brings me to your 1996 and 2007 judgments in the Bosnian genocide case, and to Ukraine's claim that a direct responsibility of a state for itself financing acts prohibited by the ICSFT is inherent in the obligation to cooperate to prevent laid down in Article 18 of the Convention. Such reliance is, however, unfounded for several reasons, each of which individually would suffice to set aside the reliance by Ukraine on your jurisprudence in the Bosnian genocide case to support its overbroad interpretation of the ICSFT generally and its Article 18 in particular. For one, when circumscribing the scope of the obligation to prevent genocide in 2007, the Court was very careful to underline that, quote, the content of the duty to prevent varies from one instrument to another according to the wording of the relevant provisions and depending on the nature of the acts to be prevented, end quote. Accordingly, the Court, quote, confined itself to determining the specific scope of the duty to prevent in the Genocide Convention, end quote, as well as its legal consequences. What is more is that the Court stressed that it did not, quote, purport to establish a general jurisprudence applicable to all cases where a treaty instrument or other binding legal norm includes an obligation for states to prevent certain acts, end quote. As a matter of fact, let me recall that Article 18 does not, unlike the Genocide Convention, oblige contracting parties to generally prevent the financing of terrorist activities. Rather, state parties of the ICSFT are only obliged, quote, to cooperate in the prevention, end quote, of certain specific acts, respectively are merely obliged to cooperate in the prevention by considering to take certain action. This textual difference alone suffices, in line with your jurisprudence, to show that the mechanic transposition of the Court's 2007 holding by replacing genocide, le crime des crimes, by the financing of alleged terrorist acts, as Professor Koh literally did. Such mechanic transposition is inappropriate and misplaced. Besides, the Court based its 2007 finding that the Genocide Convention covers matter of state responsibility, inter alia on the fact that the Genocide Convention categorizes genocide as a crime under international law, un crime du droit des gens. Yet, unlike the Genocide Convention, the ICSFT simply does not contain such a characterization. Moreover, unlike as in the case of the Genocide Convention, there seems to be nothing paradoxical in limiting the scope of the ICSFT to issues of individual and corporate responsibility, as Article 5 confirms. Rather, it is only such a narrow interpretation that would keep the ICSFT fully in line with the other manifold suppression treaties dealing with mutual criminal assistance. Put otherwise, interpreting the ICSFT in the way the applicant wants the Court to interpret it would mean that all the other conventions which aim at suppressing certain acts by obliging states parties to undertake measures to prevent the respective acts would have to be understood in exactly the same manner. Beyond, there lies nothing extraordinary in the fact that issues of state responsibility are excluded from the scope of the ICSFT, since the issue of state responsibility for financing acts of terrorism would obviously continue to be governed by other rules of international law, and namely by the prohibition of non-intervention, as confirmed by the Court's jurisprudence. Finally, the extension of the scope of application of the Genocide Convention to also cover issues of state responsibility was justified by the fact that the notion and the concept of genocide for purposes of individual responsibility on the one hand and for purposes of state responsibility on the other hand are identical. What is more, that there is also identity between the notion of genocide in customary international law and under the Genocide Convention. In contrast, when it comes to the notion of terrorism, and specifically the obligation to suppress the financing of terrorist acts, the ICSFT constitutes more than a mere codification of pre-existing rules of customary international law, as indeed confirmed by the jurisprudence of the STL to which Ukraine itself referred. Hence, extending the scope of the Convention to also cover matters of state responsibility for states financing alleged terrorist acts would involve a codification of international law as far as the principle of non-intervention and related issue of jus ad bellum are concerned, and submitting those issues to the Court's jurisdiction under Article 24 ICSFT, which bold steps the negotiating states had, as previously shown, simply not wanted to take when adopting the ICSFT. Let me finally address the issue of the ICSFT's compromissory clause. While it is obviously true that such clauses cannot give rise to or deny substantive rights, the substantive clauses of a treaty have nevertheless to be construed in harmony and coherent with its compromissory clause. As the Court itself has done twice in the Bosnian genocide case, both in 1996 and then again in 2007. Hence, the fact that Article 24 ICSFT, unlike Article 9 Genocide Convention, deliberately does not encompass issues of state responsibility for a state allegedly financing terrorist acts must be taken at face value and into account when making a finding as to whether, or rather not, issues of state responsibility are covered by the substantive provisions of the ICSFT. Besides, as previously mentioned already 2 days ago, Article 4 Genocide Convention, as well as the lack of a parallel provision in the ICSFT with its specific reference to organs of a state committing treaty violations, must be also taken at face value, as the Court did already in 1996, actually contrary to what Ms. Cheek claimed. On the whole, therefore, while Article 1 Genocide Convention read in conjunction with Article 4 and Article 9 Genocide Convention was rightly perceived by the Court as providing for state responsibility under the Genocide Convention, Article 18 ICSFT in turn cannot serve as a magic key providing for state responsibility for alleged acts of financing terrorism well beyond the parameters of the text of the ICSFT. Let me very briefly turn to urgency. As far as urgency is concerned, I can be brief and simply remind the Court that it ought only be concerned with urgency based on plausibly alleged violations of the ICSFT as such, but not be concerned with alleged violations of IHL as such, which are beyond the scope of the Court's prima facie jurisdiction, and which therefore cannot be the reason for urgency for purposes of these very proceedings. Mr. President, let me conclude. Let there be no doubt. If Ukraine was correct, Nicaragua type of cases involving the provision of financial support to insurgents, which might commit violations of IHL, could become a matter of routine, be it with regard to the support of non-state actors in Syria, or be it elsewhere throughout the world. The same might be true for a scenario like the one that was adjudicated by the Arbel Tribunal in the Rainbow Warrior case. Mr. President, members of the Court, in Ukraine's reading, Article 24 ICSFT would therefore become a skeleton key widely opening the jurisdictional gates of the Peace Palace, covering broad areas of international law. Let me therefore respectfully remind you of the prudent words of President Chimneste Arachaga that the Court's power under Article 41 of the statute does not consist in a general police power over the maintenance of international peace or in a general competence to settle disputes, but that they are meant and meant only to preserve the rights of both parties within the specific limits of the Court's jurisdiction as circumscribed by a given compromissory clause, and that is Article 24 ICSFT at the case at hand. This concludes my argument. Thank you very much for your attention, Mr. President, members of the Court.
Merci, Monsieur le Professeur. Je crois que le moment est venu de faire, comme il est d'usage, une pause qui durera 15 minutes. La séance est suspendue. Veuillez vous asseoir. Je donne maintenant la parole au professeur Fourteau.
Monsieur le Président, Mesdames et Messieurs de la Cour, je dispose ce matin d'un peu plus de temps que mardi, ce qui me permettra de parler à un rythme plus satisfaisant pour les interprètes, les membres de la Cour et le greffe, auxquels je présente mes plus vives excuses pour la cadence un peu trop énergique de ma précédente plaidoirie. Monsieur le Président, avant d'en venir aux questions qui divisent encore les parties en ce qui concerne la Convention CERD, permettez-moi de commencer par souligner qu'il existe un point d'accord entre elles. Il n'y a pas de différend quant au fait que, quel que soit le statut de la Crimée, la Russie doit appliquer la Convention CERD sur ce territoire. Cela, du même coup, prive d'effet les deux premières demandes de mesures conservatoires de l'Ukraine. Cette précision étant faite, j'en viens au cœur du débat entre les parties. Comme j'avais eu l'occasion de le souligner mardi, les accusations portées par l'Ukraine contre la Russie présentent un caractère d'une exceptionnelle gravité, et c'est au regard de ces accusations que la Cour doit mesurer s'il convient d'imposer des mesures conservatoires. Toute mesure conservatoire que la Cour pourrait prononcer dans ce volet de l'affaire serait nécessairement interprétée et commentée à la lumière de cette grave accusation à laquelle un certain crédit serait ainsi donné. Telle est la raison pour laquelle il est nécessaire que la Cour s'assure avec rigueur de la plausibilité des accusations ukrainiennes. L'Ukraine, de son côté, vous demande de vous prononcer les yeux bandés. Comme les conseils de l'Ukraine l'ont répété à plusieurs reprises hier, au point de jeter un doute sérieux sur la crédibilité qu'eux-mêmes accordent à leur demande, la Cour devrait adopter un standard très peu exigeant pour apprécier à la fois sa compétence prima facie et les conditions posées à l'imposition de mesures conservatoires. Vous devriez uniquement déterminer si l'interprétation proposée par le demandeur de la Convention CERD est plausible, sans vous intéresser aux faits de l'affaire. Ainsi, selon M. Gimblet, « You do not need to enter into the merits of this case to conclude that a plausible right needs protection. » Pareille affirmation est évidemment contraire à votre jurisprudence qui indique qu'au stade des mesures conservatoires, il vous appartient de déterminer si les circonstances exigent l'imposition de telles mesures, ce qui exige de s'assurer de la plausibilité des demandes formulées. En la présente instance, l'examen de la demande de l'Ukraine, tel que celle-ci l'a étayé, conduit à conclure que ce seuil n'est pas atteint. Pour rappel, l'objet de la demande de l'Ukraine n'est pas de faire constater l'existence d'une discrimination en particulier. Une discrimination, par exemple, dans l'accès à un type d'emploi, ou une discrimination dans les règles applicables en matière d'héritage, qui exigerait de la Cour qu'elle adopte une mesure conservatoire précise, visant à sauvegarder un droit particulier qui serait en litige. Ce que demande l'Ukraine est de nature bien différente. L'Ukraine allègue que la Russie se livrerait à une campagne systématique d'annihilation culturelle des populations tatares et ukrainiennes de Crimée. Le professeur Coe a confirmé hier que tel est bien l'objet de la demande de l'Ukraine. Selon lui, il existerait, je cite, « a policy of Russification that inflicts collective punishment and pervasive discrimination against other cultures. Cette campagne systématique constituerait, selon l'Ukraine, un effort concerté, a concerted effort, de suppression de ces communautés. Ces graves accusations se retrouvent dans la demande elle-même de mesures conservatoires. Ce que l'Ukraine demande à la Cour, ce n'est pas de mettre fin à une pratique particulière de discrimination, c'est de mettre fin aux prétendus acts of political and cultural suppression against les communautés tatares et ukrainiennes de Crimée. Dans ces circonstances, et n'en déplaise à M. Gimblet, le standard de preuve établi par la Cour pour des accusations d'une telle gravité s'applique dans le cadre de l'examen du test de plausibilité. D'évidence, et j'aurai l'occasion d'y revenir en détail, ce test n'est pas rempli en l'espèce. Peut-on soutenir qu'une campagne systématique d'annihilation culturelle serait en cours en Crimée, alors que, comme je l'ai rappelé mardi, l'éducation en tatar et ukrainien est assurée dans de nombreuses écoles et universités, et que plus de 80 médias sont autorisés à émettre en langue tatare et ukrainienne en Crimée. Comment réconcilier les allégations ukrainiennes avec les mesures constitutionnelles, législatives et administratives qui ont été adoptées depuis 2014 pour assurer la protection des droits des communautés tatares et ukrainiennes, y compris par le biais de l'inscription dans la constitution de la Crimée de ces langues comme langue officielle de la Crimée. La seule réponse fournie par l'Ukraine hier aux éléments présentés mardi par la Russie a consisté d'une part à affirmer péremptoirement, je cite, que « we know from the practice of the Soviet Union that there can be a wide gulf between what is written in law and what happens on the ground ». D'autre part, à faire part d'une série de spéculations censées permettre d'établir que le seuil de plausibilité serait atteint en l'espèce. Je laisse le soin à la Cour d'apprécier la valeur de ces arguments. Le seul document présenté par l'Ukraine hier pour contester l'existence de ces acquis constitutionnels, législatifs et administratifs est une photo montrant qu'un écriteau à l'entrée d'un bâtiment ne serait pas encore traduit dans les 3 langues officielles de la Crimée. Il se trouve cependant que ce bâtiment n'est pas un bâtiment officiel. Le fait que l'Ukraine n'ait pas produit d'autres documents confirme à contrario que la règle des 3 langues officielles est effectivement respectée en pratique, comme le prouvaient déjà les nombreux documents soumis par la Russie mardi. Au bénéfice de ces remarques préliminaires, je souhaiterais ce matin revenir sur 4 points en particulier, en réponse aux arguments présentés hier par l'Ukraine. Je dirai quelques mots d'abord, très brefs, de l'objet et du champ d'application de la Convention CERD, avant de revenir plus en détail sur chacune des 2 conditions préalables découlant de l'article 22 de la Convention, et enfin sur les raisons pour lesquelles il n'est ni nécessaire ni possible de prononcer en l'espèce des mesures conservatoires. Le professeur Coe a fait semblant hier de mal comprendre les précisions que j'ai pu apporter mardi quant au champ d'application de la Convention CERD. Contrairement à ce qu'il a affirmé, la Russie n'a nullement admis avoir violé les droits de l'homme en Crimée. Le point pertinent est le suivant. La Convention CERD n'est ni les pactes internationaux de 1966, ni la Convention européenne des droits de l'homme, auxquels les 2 États sont partis d'ailleurs, et qui comportent leur propre mécanisme de contrôle. La Convention CERD n'est pas davantage un instrument visant à renforcer et promouvoir les droits des minorités. La Convention CERD a un objet nettement délimité. Elle vise à l'élimination des discriminations raciales. Cela emporte une conséquence importante. La compétence de la Cour, en l'espèce, se limite aux griefs selon lesquels il y aurait eu, dans la jouissance de certains droits, une discrimination. Il semble que l'Ukraine ait réalisé hier que tel était l'objet précis de la Convention. L'Ukraine a admis en effet qu'il lui fallait établir l'existence d'une différence de traitement entre des communautés différentes pour pouvoir se prévaloir de la Convention. Mais le fait est qu'à ce jour, l'Ukraine n'a apporté aucun élément démontrant une telle différence de traitement. L'Ukraine s'est contentée d'alléguer des violations de droits de l'homme sous une forme souvent sujette à caution. Ainsi, le professeur Ko a accusé lundi la Russie d'avoir eu recours contre un responsable tatar à, je cite, « a barbaric Soviet-era practice subjecting a Tatar leader to involuntary psychiatric detention ». Mais il semblerait que cette procédure existe également en Ukraine. Cette procédure consiste en ce qu'un juge peut ordonner un examen psychiatrique d'une personne qui est sujette à enquête pénale lorsque son état le justifie. Le seul argument avancé hier par l'Ukraine sur le terrain de la discrimination a consisté à citer un extrait d'un rapport de mai 2016 qui allègue que certains groupes paramilitaires auraient échappé à des poursuites pour extrémisme, alors que des activistes tatars auraient, eux, été poursuivis. Le principe de non-discrimination ne peut cependant servir à légitimer l'impunité lorsqu'un comportement mérite une sanction. En tout état de cause, j'ai cité mardi un rapport récent de plus de 100 pages qui montre que la législation extrémiste est appliquée sans discrimination. L'Ukraine a préféré, quant à elle, ne pas commenter ce document hier. J'en viens à la question des négociations préalables. Je me concentrerai ce matin sur les points qui sont particulièrement importants à ce stade de l'instance. Premièrement, il résulte des échanges diplomatiques entre les deux parties que celles-ci n'ont pas abordé tous les éléments qui font l'objet de la requête de l'Ukraine. Cela signifie, au regard de votre jurisprudence, que la condition de négociation préalable ne peut pas être considérée comme remplie. Tout d'abord, l'Ukraine n'a jamais formulé, dans aucune des notes diplomatiques échangées entre 2014 et 2016, l'accusation selon laquelle la Russie se livrerait à une campagne systématique d'annihilation culturelle de certaines communautés. Cette grave accusation, qui est au centre de la demande de l'Ukraine, n'est apparue pour la première fois que dans la requête. Ensuite, les notes diplomatiques de l'Ukraine ont uniquement invoqué les articles 2 et 5 de la Convention, comme M. Gimblet l'a lui-même remarqué lundi dernier. Or, dans sa requête, l'Ukraine a également évoqué les articles 3, 4 et 6 de la Convention et formulé des griefs sur leur base. La demande de mesures conservatoires sollicite également la protection des droits découlant des articles 3, 4 et 6. N'ayant pas été invoqués avant la requête, ces articles et les obligations qu'ils contiennent n'ont pas pu faire l'objet de négociations préalables. Cela jette du même coup un doute sur la portée exacte des mesures conservatoires demandées par l'Ukraine. Celle-ci a expressément demandé, dans sa demande écrite en mesures conservatoires, à ce que ces mesures protègent ses droits en vertu des articles 2, 3, 4, 5 et 6. Mais il n'y a eu aucune négociation préalable sur les articles 3, 4 et 6. Mardi, M. Gimblet nous a dit que la demande de l'Ukraine, je cite, « repose sur « many articles of the third », mais qu'il se concentrerait uniquement sur les articles 2 et 5, les seuls articles qu'il a ensuite invoqués. À défaut de clarification apportée par l'Ukraine quant aux droits exacts dont elle demande la protection, la Cour n'est pas en mesure de se prononcer clairement sur sa demande. La deuxième remarque importante concerne le standard applicable en la matière. Les conseils de l'Ukraine ont fait fond hier sur l'ordonnance rendue par la Cour en 2008 dans l'affaire Géorgie contre Russie. Mais outre que les faits de cette affaire n'ont rien de comparable à ceux de la présente affaire, comme je l'ai indiqué mardi, il se trouve que depuis 2008, la Cour a eu l'occasion d'examiner en détail le régime applicable aux préconditions fixées par l'article 22 de la Convention serbe, et en particulier la condition de négociation préalable. La situation n'est donc plus la même qu'en 2008. Il faut désormais tenir compte des importantes précisions apportées par la Cour dans son arrêt de 2011, dans l'affaire Géorgie contre Russie, et dans les développements ultérieurs de sa jurisprudence. Troisièmement, la manière dont l'Ukraine s'est comportée durant les négociations confirme qu'elle n'estimait pas que ces demandes appelaient une réponse urgente ou exigeaient que des mesures soient prises urgemment pour protéger provisoirement ses droits. Pour ne prendre que quelques exemples, dans sa note verbale du 1er décembre 2014, l'Ukraine a informé la Russie qu'elle estimait avoir d'ores et déjà épuisé la condition de négociation préalable. Pourtant, l'Ukraine a accepté de prolonger les échanges et discussions pendant 2 ans, sans à aucun moment préciser que ses droits en vertu de la Convention risquaient de manière imminente de subir un préjudice irréparable. L'Ukraine a laissé passer un laps de temps parfois considérable entre 2 échanges diplomatiques. Ainsi, après la session de discussion d'avril 2015, l'Ukraine a repris le fil du dialogue qu'en août 2015, soit 4 mois plus tard. Dans cette note verbale du 17 août 2015, l'Ukraine n'a de nouveau invoqué aucune urgence. Au contraire, elle a rappelé que les 2 parties, je cite, « agreed to continue working on overcoming the differences through at least one more round of negotiations ». Nous sommes le 17 août 2015. Il faudra attendre plusieurs mois pour que l'Ukraine envoie une nouvelle note verbale. Dans la note du 5 avril 2016, l'Ukraine propose que les négociations continuent et que se tienne une 2e réunion de discussion, là encore sans invoquer le moindre risque imminent de préjudice irréparable. La même attitude sera suivie par l'Ukraine dans sa dernière note, en date du 7 octobre 2016. Aucune urgence ne fut invoquée, et au contraire, et je le souligne, l'Ukraine proposa de continuer les consultations. M. Zayants a toutefois prétendu hier que l'Ukraine aurait plusieurs fois indiqué qu'il y avait urgence. Mais il n'a cité qu'un seul exemple, qui n'est guère probant. Dans la note du 25 avril 2016, soit il y a presque un an, l'Ukraine aurait selon lui objecté, sur une base urgente, à l'interdiction du Mejlis. Mais ce que cette note montre en réalité, c'est que l'Ukraine a seulement demandé à la Russie d'être prête à fournir des commentaires sur ce point lors de la prochaine session de discussion. Et dans les notes diplomatiques qui ont suivi, l'Ukraine n'a pas demandé à la Russie de suspendre la mesure d'interdiction du Mejlis. Ceci jette un doute sur l'allégation de l'Ukraine selon laquelle désormais il y aurait urgence à le faire. Avec votre permission, Monsieur le Président, il me faut maintenant revenir sur l'importante question relative à la 2e précondition qui découle de l'article 22 de la Convention. Le professeur Coe a soutenu sur ce point hier que le fait que l'article 11 prévoit que le comité CERD peut être saisi de plaintes interétatiques signifie que sa saisine n'est pas une condition préalable à la compétence de la Cour. L'argument est sans fondement. L'article 11 donne la possibilité à un État de déclencher la procédure de plainte interétatique. Ses rédacteurs ne pouvaient évidemment pas lui faire dire que lorsqu'un État partie estime qu'un autre État partie viole la Convention, il doit alors saisir le comité. une clause obligeant les États parties à saisir un mécanisme de règlement des différends eût été un précédent bien surprenant. Comme chacun le sait, la question juridique pertinente est de savoir si l'article 22, et non l'article 11, oblige à faire recours au comité avant la saisine de la Cour. M. Zayand a tenté de répondre à cette question, mais de manière pour le moins surprenante. Il a d'abord affirmé que la position de la Russie, exposée dans l'affaire Géorgie contre Russie, selon laquelle les deux conditions sont cumulatives, aurait été, je le cite, « been rejected by every member of the court to decide on it ». Il est vrai qu'au stade de la compétence dans cette affaire, certains membres de la Cour ont considéré dans leurs opinions que l'article 22 devait plutôt s'interpréter comme imposant de conditions alternatives et pas cumulatives. Mais sept autres membres de la Cour ont quant à eux estimé que la Cour aurait dû également appliquer la deuxième précondition dans cette affaire au stade des mesures conservatoires. Ceux-ci ont en particulier pointé le fait qu'il existe une procédure d'urgence devant le comité CERD qui lui permet d'intervenir avec plus d'efficacité en cas de violation de la Convention. Cela montre, au minimum, que la question du recours préalable au comité CERD se pose sérieusement et qu'elle ne peut être balayée d'un revers de la main, comme le fait l'Ukraine. L'Ukraine soutient pourtant que, je cite, « Little needs to be said of that argument at this stage, where again the only question is prima facie jurisdiction ». Monsieur le Président, je vous avouerai avoir perdu ici le fil de l'argumentation ukrainienne. D'un côté, l'Ukraine consacre une plaidoirie entière à la question des négociations, alors qu'elle estime avoir satisfait cette condition. De l'autre, elle estime ne rien devoir dire du tout sur le recours préalable au comité, alors qu'elle admet n'avoir même pas cherché à épuiser cette condition préalable. La seule indication fournie par l'Ukraine hier est qu'elle ne croit pas que la Russie has the correct reading of Article 22. Mais, Monsieur le Président, c'est précisément la question. Cette réponse de l'Ukraine est d'autant plus insuffisante que la lecture ukrainienne de l'article 22 est lourde de conséquences. Si la Russie comprend bien, l'Ukraine reprend à son compte la position juridique qui avait été celle du demandeur dans l'affaire Géorgie contre Russie. Selon cette position, cela ne poserait aucune difficulté de court-circuiter le comité CERD en acceptant qu'un État puisse porter directement sa prétention devant la Cour internationale de justice. Ne pas donner cependant son effet utile à la deuxième précondition de l'article 22 reviendrait à porter atteinte à la volonté des auteurs de la Convention de limiter le recours à la Cour, volonté dont la Cour a elle-même pris note dans son arrêt de 2011. Cela priverait également de tout effet utile la procédure de plainte interétatique expressément introduite aux articles 11 à 13 de la Convention, alors qu'en 2011, la Cour a insisté sur le nécessaire respect du principe de l'effet utile. Cela affecterait gravement, enfin, la compétence du comité CERD et plus largement l'équilibre institutionnel établi par la Convention CERD. Or, comme votre Cour l'a souligné en 2010 dans l'affaire Diallo, il appartient à la Cour, je cite, d'accorder une grande considération à la pratique de tout organe indépendant spécialement établi en vue de superviser l'application d'un traité. Cette grande considération est un élément utile pour éviter la fragmentation du droit international et les appréciations ou interprétations divergentes d'une même convention. Elle est d'autant plus requise ici que la Convention CERD présente la particularité d'avoir institué une procédure de plainte interétatique devant un tel comité. Court-circuité, le comité CERD dans la présente affaire est d'autant moins envisageable, par ailleurs, que d'une part, il assure depuis de nombreuses années le suivi du sort réservé aux communautés de Crimée. D'autre part, il est, et je parle au présent, il est saisi depuis l'été dernier du rapport périodique de la Russie sur lequel le dialogue institutionnel va s'ouvrir en août prochain avec le comité. En admettant quod non que la Cour ait compétence prima facie sur le fondement de l'article 22 de la Convention, les circonstances ne sont pas telles que des mesures conservatoires devraient être prononcées. À ce titre, il convient de souligner d'abord que les mesures demandées par l'Ukraine sont soit d'un très grand flou, soit clairement excessives. S'agissant du premier point, il est difficile de saisir exactement quelles mesures l'Ukraine souhaiterait voir adoptées par la Cour. À aucun moment, en effet, l'Ukraine n'a défini ce qu'elle entend concrètement par sa demande visant à obtenir la cessation, je cite, des acts of political and cultural suppression. En ce qui concerne par exemple la question des disparitions, dans la mesure où la dernière disparition remonte à mai 2016 et où celle-ci n'a pas été attribuée à la Russie, il est difficile de comprendre la portée exacte de la demande de l'Ukraine. Pour prendre un autre exemple qui concerne la langue ukrainienne, l'incertitude est également totale quant à ce que l'Ukraine demande exactement. S'agit-il de modifier le système suivant lequel les familles émettent leurs vœux en ce qui concerne la langue d'études de leurs enfants? S'agit-il d'augmenter le nombre d'enseignants ou de classes en langue ukrainienne? En ce qui concerne les médias, plus de 80 d'entre eux ont été autorisés à émettre en Crimée, en langue tatare et ukrainienne. Que demande concrètement, en guise de mesures conservatoires, l'Ukraine sur ce point pour protéger ses droits? L'incertitude est totale en la matière. Par exception, dans le cas du Mejlis, l'Ukraine sollicite de la Cour une demande précisément définie. L'Ukraine exige, en effet, la suspension de l'interdiction du Mejlis. Mais une telle demande ne peut pas être ordonnée par la Cour pour au moins 3 raisons. Tout d'abord, l'interdiction du Mejlis ne repose sur aucun motif de discrimination raciale. Elle tombe donc en dehors du champ de la Convention. Par ailleurs, c'est un principe bien établi dans la jurisprudence de la Cour que sa décision sur les mesures conservatoires, je cite, doit laisser intact le droit de chacune des parties de contester les faits allégués contre elle, ainsi que la responsabilité qui lui est imputée quant à ces faits. Ordonner la suspension du décret interdisant le Mejlis reviendrait à l'inverse à préjuger le fond de l'affaire, en estimant que cette interdiction ne serait pas fondée sur des motifs objectifs et raisonnables et serait en réalité exclusivement motivée par une volonté de discrimination raciale, volonté au demeurant que l'Ukraine n'a même pas tenté d'établir. L'Ukraine s'est contentée de conjectures selon lesquelles la lutte contre l'extrémisme ne serait qu'un prétexte déguisant d'autres motifs. Enfin, il convient de prendre en considération les conséquences qu'aurait une telle suspension. La décision de la Cour suprême de Crimée, qui a confirmé l'interdiction et qui figure en document numéro 56 du dossier des juges de la Russie de mardi dernier, détaille les motifs qui ont conduit les autorités à estimer que le Mejlis se livrait à des activités extrémistes en Crimée. Ces motifs sont sérieusement étayés par la Cour suprême de Crimée, qui, de la page 11 à la page 19 de la décision, dresse en particulier la liste des déclarations publiques faites par des responsables du Mejlis, déclarations qui sont disponibles sur Internet, comme la Cour le relève pour chaque déclaration. Le contenu de ces déclarations est explicite. les dirigeants du Mejlis ont qualifié ceux qui ne luttent pas contre la Russie de collaborateurs, ont encouragé à déclarer la guerre à la Russie, ont estimé que leur objectif est de libérer la Crimée en mettant en place un blocus, ont appelé à la cessation de tout commerce, y compris la fourniture de l'électricité avec la Crimée, et ont même assumé le fait qu'à travers le blocus mis en place, je cite, « We, as activists, as the Mejlis, created a humanitarian catastrophe in Crimea ». M. Gimblett a relevé par ailleurs que les motifs d'interdiction du Mejlis remontent également à des actes qui ont pu être commis avant 2014, ce qui avait conduit l'Ukraine elle-même à prendre des mesures contre le Mejlis. Dans ses rapports de décembre 2015 et de mars 2016, qui concernent la période critique relative à l'interdiction du Mejlis, le haut-commissaire des droits de l'homme des Nations Unies avait déjà exprimé ses plus vives inquiétudes quant aux conséquences du blocus contre la Crimée et aux violations des droits qui l'ont accompagné. En particulier parce que les personnes qui ont mis en œuvre ce blocus se sont substituées aux autorités compétentes de manière illégale. Dans son rapport de mars 2016, le haut-commissaire écrit par ailleurs ceci, je cite, « The civil blockade was operated by activists who illegally performed law enforcement functions and was marked by some human rights abuses. » À la lumière de ces éléments, il est difficile de prétendre que la Russie n'était manifestement pas en droit d'interdire le Mejlis et de prendre les mesures nécessaires à la protection de l'ordre public. Dans son rapport de décembre 2016, le haut-commissaire aux droits de l'homme est revenu sur ces événements en détaillant les raisons pour lesquelles la loi contre l'extrémisme a été appliquée. Il n'a pas prétendu à cette occasion qu'il y aurait eu là un exemple de discrimination raciale. M. Gimblett a affirmé hier toutefois que cette loi contre l'extrémisme serait arbitraire car elle serait trop large dans sa définition. Cet argument, en supposant qu'il soit fondé, n'a aucune pertinence en l'espèce. Une loi arbitraire ne peut de toute manière tomber sous le champ de la Convention CERD que si elle est mise en œuvre de manière discriminatoire pour des raisons raciales, ce qui n'est pas le cas en l'espèce. Le haut-commissaire aux droits de l'homme a par ailleurs indiqué ceci dans son rapport de décembre 2016 à propos de la détention de 2 personnes ayant participé à ces activités extrémistes. Je cite, « Le 10 octobre, une cour de Crimée a prolongé jusqu'au 10 décembre la détention provisoire de Yevhen Panov et Andriy Yaktey, un autre suspect arrêté. Plus tôt, en août, la Cour européenne des droits de l'homme avait refusé d'ordonner l'extradition de Yevhen Panov vers l'Ukraine, comme le demandait sa famille, qui invoquait l'article 39 du règlement de la Cour, qui concerne les mesures conservatoires, et le risque de torture en détention. La Cour européenne a plutôt accepté la position de la Fédération de Russie, selon laquelle les autorités russes examineront les plaintes de l'accusé et enquêteront sur les conditions dans lesquelles il a subi des blessures. Fin de citation. Ce passage du rapport du haut-commissaire est important à 2 points de vue. Il montre que, contrairement aux spéculations de l'Ukraine, il n'y a pas lieu de présumer par principe que la Russie ne respecte pas ses engagements internationaux en matière de droits de l'homme en Crimée. Il montre également que le respect des droits de l'homme en Crimée est strictement contrôlé par la Cour européenne des droits de l'homme, notamment par le biais du recours possible, mais refusé en l'espèce, aux mesures conservatoires. Dans le même rapport de décembre 2016, et toujours en ce qui concerne la lutte contre l'extrémisme, le haut-commissaire a fait état de sérieuses inquiétudes en ce qui concerne les poursuites contre les membres du Hizb ut-Tahrir de Crimée, dont certains sont des Tatars de Crimée. Le haut-commissaire n'a toutefois pas précisé en quoi consistaient ces inquiétudes. Je rappellerai à cet égard que cette organisation est interdite et a été considérée par la Cour européenne des droits de l'homme comme extrémiste. L'Ukraine n'a pas commenté hier les 2 arrêts de la Cour européenne des droits de l'homme que j'avais cités mardi. Ces arrêts sont pourtant fort intéressants. Les demandeurs dans ces affaires ont vu leur plainte déclarée inadmissible par la Cour au motif, et c'est un motif que la Cour ne retient qu'en de très rares occasions, au motif que la nature des activités de Hizb ut-Tahrir lui interdisait de formuler la moindre plainte devant la Cour européenne des droits de l'homme, dès lors que ces activités doivent être vues comme visant à la destruction des droits et libertés prévus par la Convention. Il s'agit d'une application de l'article 17 de la Convention européenne des droits de l'homme. Pour conclure sur ce point, dans son rapport de décembre 2016, toujours, le haut-commissaire n'a exprimé aucune critique quant à la décision de la Cour suprême de Crimée d'interdire le Mejlis. Il a certes remarqué que, selon lui, aucune des 30 ONG tatares de Crimée n'ont le même degré de représentativité et de légitimité que le Mejlis et le Kurultai. Mais il n'a pas condamné pour autant la décision d'interdiction. Cet extrait montre par ailleurs que le Mejlis n'est pas considéré comme la seule entité susceptible de représenter les Tatars. Par ailleurs, le Kurultai, lui, n'a pas été interdit. Certes, dans un rapport présenté 6 mois plus tôt, dont M. Gimblet se prévaut, le haut-commissaire avait relevé que l'interdiction du Mejlis could be perceived as a collective punishment against the Crimean Tatar community. Mais ce constat factuel, exprimé d'ailleurs en termes hypothétiques et subjectifs, n'implique certainement pas à lui seul que l'interdiction du Mejlis constituerait un acte de discrimination raciale. Au vu de l'ensemble de ces circonstances, rien ne justifie donc la suspension de l'interdiction du Mejlis. Au contraire, une telle mesure aurait de graves conséquences pour la sécurité de la Crimée, tout en préjugeant gravement les droits de la Russie au fond, à supposer que la Cour ait compétence en l'espèce, ce qui n'est pas le cas. Permettez-moi maintenant, Monsieur le Président, de revenir sur une dernière série d'affirmations avancées hier par l'Ukraine en relation avec la plausibilité de sa demande. Le leitmotiv de l'Ukraine a été de vous recommander de ne pas trop regarder les faits ni le fond de l'affaire. Elle a estimé qu'il suffisait à la Cour de s'en tenir à ce qui figure dans la résolution de l'Assemblée générale des Nations unies de décembre 2016 en guise d'établissement des faits. Monsieur le Président, cela ne saurait évidemment suffire au moment de décider si la Cour doit imposer, par voie de mesures conservatoires, des obligations contraignantes à un État souverain. L'Assemblée générale n'est pas un organe d'établissement des faits. Par ailleurs, la résolution en cause avait à l'évidence un caractère politique marqué. Elle n'a été adoptée que par 70 États, tandis que 26 ont voté contre et 77 se sont abstenus. En tout état de cause, la résolution de l'Assemblée générale a été rédigée avant la remise du dernier rapport du Haut-Commissaire des Nations unies aux droits de l'homme. Dans ce rapport soumis en décembre 2016, le Haut-Commissaire indique en effet que le 15 novembre 2016, la 3e commission de l'Assemblée générale avait déjà adopté la résolution en question. Ceci emporte 2 conséquences. La première est que le Haut-Commissaire a soumis son rapport en ayant connaissance du contenu de cette résolution, dont il était donc en mesure de confirmer les conclusions dans son rapport si elles correspondaient aux informations qu'il avait collectées. La seconde est que le rapport du Haut-Commissaire de décembre 2016 est le document le plus récent. Ce rapport ne saurait certes être décisif au regard des critères fixés par votre jurisprudence en matière de preuves qui favorisent les documents établis par des personnes ayant une connaissance directe des faits ou bien établis selon une méthodologie judiciaire rigoureuse. Le contenu de ce rapport est toutefois intéressant à plusieurs titres. Les éléments suivants sont notamment particulièrement éclairants. Les paragraphes 155 à 181 du rapport, qui sont dédiés à l'examen de la situation en Crimée, ne contiennent pas une seule fois le terme discrimination. Le terme discrimination figure en revanche plusieurs fois dans d'autres sections du rapport, mais dans les passages qui concernent les mesures à prendre par les autorités ukrainiennes. Dans la partie du rapport consacrée aux mesures à prendre par l'Ukraine, il y a même une section entière dédiée aux droits des minorités et à la discrimination. Dans la partie du rapport consacrée à la Crimée, il y a également une section sur les droits des minorités, mais celle-ci ne vise pas la discrimination et demeure complètement muette à son sujet. Le dit rapport ne mentionne à aucun endroit par ailleurs l'idée qu'une campagne d'annihilation culturelle serait en cours. Nul doute que si tel était le cas, le haut-commissaire l'aurait mentionné. Au paragraphe 170 et 171, le haut-commissaire s'inquiète en revanche des barrières juridiques et administratives disproportionnées imposées par l'Ukraine qui encouragent la corruption et limitent la liberté de mouvement entre l'Ukraine continentale et la Crimée, et souligne que cette question est devenue particulièrement aiguë. Il fait état sur ce point de plaintes répétées, tant de la part des habitants de l'Ukraine continentale que de la Crimée. Dans la section consacrée à la Crimée, le rapport passe par ailleurs en revue le respect de plusieurs droits, dont le droit à un procès équitable et les droits des détenus, sans à aucun moment faire état de la moindre allégation de discrimination raciale dans la jouissance de ces droits. Certes, au paragraphe 178, le haut-commissaire évoque des rapports qui auraient circulé sur des pressions et des fouilles contre des militants tatars de Crimée et des membres du Medjlis, mais il précise que cela concerne des personnes qui préconisaient un boycott des élections. La dernière partie de la section du rapport portant sur la Crimée aborde, en 3 paragraphes, 179 à 181, le droit à l'éducation. Le haut-commissaire y constate tout d'abord que les parents tatars de Crimée semblent adopter la possibilité d'éduquer leurs enfants en langue tatare de Crimée. Il avance ensuite des chiffres en citant une organisation non gouvernementale tatare de Crimée sur ce point précis, qui démontre que la langue tatare est enseignée en Crimée à près de 1000 élèves, étant précisé qu'il y a une école de plus qu'en 2014 qui enseigne cette langue. Il ne fait état par ailleurs d'aucune préoccupation à propos de l'éducation en langue tatare. En ce qui concerne l'ukrainien comme langue d'éducation, le haut-commissaire se contente de confirmer qu'il est en déclin continu depuis mars 2014. À aucun moment, cependant, le haut-commissaire ne prétend que ce serait en raison de restrictions imposées par les autorités de Crimée, contrairement à ce qu'a affirmé mardi l'Ukraine. Le seul commentaire qu'il formule consiste à citer les autorités de Crimée, selon qui ce déclin peut être attribué à un manque d'intérêt pour l'enseignement en ukrainien parmi les parents. Je précise en passant sur ce point qu'il n'y a aucune contradiction entre le rapport soumis par la Russie à l'UNESCO en avril 2015, le rapport du haut-commissaire et les statistiques fournies à la Cour par la Russie en ce qui concerne la liste des écoles en langue ukrainienne. Il se trouve simplement que ce dernier document, à la différence des deux autres, ne porte pas seulement sur les élèves qui ne sont éduqués qu'en langue ukrainienne. J'ajouterai toujours en relation avec les questions éducatives que c'est à tort que M. Gimblett a accusé la Russie d'avoir mal cité le rapport du comité CERD sur l'Ukraine en 2016. La Russie maintient sa citation qui montre que les Tatars de Crimée qui se rendent en Ukraine rencontrent de sérieuses difficultés, notamment en termes d'accès à l'éducation dans leur langue. Ce document est d'autant plus important qu'il contient les observations finales du comité CERD sur l'Ukraine, adoptées le 23 août dernier. Il est tout aussi important enfin de relever ce que le rapport de décembre 2016 du haut-commissaire ne contient pas. Il ne contient aucune allégation en ce qui concerne une prétendue campagne de meurtre, d'enlèvement ou de disparition. Il ne fait état par ailleurs d'aucune allégation relative à de prétendues absences d'enquête sur les disparitions survenues dans le passé. M. Gimblett a noté hier à cet égard que les autorités russes, je cite, « do not claim to have resolved the disappearances of Crimean Tatar activist Reshat Ametov in 2014 and Mr. Ibragimov himself in 2016. » De fait, ces enquêtes sont toujours en cours et M. Gimblett n'a pas prétendu qu'elles ne seraient pas ou qu'elles n'auraient pas été initiées ou menées. Le rapport du haut-commissaire ne contient par ailleurs aucune allégation en ce qui concerne la prétendue suppression des médias. Il est intéressant d'ailleurs de constater l'évolution de la demande ukrainienne sur ce point. Au premier tour de plaidoirie, l'Ukraine avait plaidé que les médias tatars et ukrainiens auraient été démantelés et supprimés en Crimée, termes qui correspondent aux mesures conservatoires sollicitées par l'Ukraine qui visent à la protéger contre toute suppression politique et culturelle. M. Gimblett s'est fait hier plus prudent en invoquant que les restrictions imposées aux médias, ce qui constitue une modification importante de la demande ukrainienne, certainement motivée par les informations présentées par la Russie à la Cour. M. Gimblett s'est limité sur ce point à soutenir que des médias comme ATR ou Addiet n'auraient pas obtenu le droit de diffuser en Crimée. Le fait est qu'ATR et Addiet n'ont pas réintroduit de nouvelles demandes d'enregistrement depuis 2015. Et cela, de toute manière, ne les prive pas d'accès à la Crimée. ATR diffuse librement ses émissions en Crimée depuis l'Ukraine, comme le montrent plusieurs offres commerciales disponibles, notamment sur Internet, qui offrent cet accès en Crimée. Quant au journal Addiet, il continue d'être publié dans la capitale de Crimée, ainsi que sur Internet, où le journal est disponible en tatar, en russe et en anglais. Le rapport du haut-commissaire de décembre 2016, ne contient enfin aucune mention d'une quelconque suppression ou restriction de droits culturels. Tout ceci conduit, mesdames et messieurs de la Cour, à une conclusion fort simple. Les circonstances de la présente affaire ne sont manifestement ni celles de l'affaire Géorgie contre Russie, ni celles dramatique et tragique qu'a tenté de décrire hier le demandeur de manière peu convaincante. Dans ces circonstances, la demande en mesures conservatoires de l'Ukraine ne peut être acceptée. Monsieur le Président, ceci met un terme à ma présentation de ce matin. Mesdames et Messieurs les juges, je vous remercie sincèrement de votre écoute. Je vous serais reconnaissant, Monsieur le Président, de bien vouloir appeler maintenant à cette barre Monsieur Roman Kolotkin, agent de la Russie.
Merci, Monsieur le Professeur. Je donne la parole à Son Excellence, Monsieur Roman Kolotkin, agent de la Russie.
Mr. President, distinguished members of the Court, concluding today's presentations, I will provide a summary of our position and deliver the final submission of the Russian Federation. As we stated at the outset of our pleadings, there are two completely different cases brought before the Court, which Ukraine artificially merged in an effort to stigmatize Donetsk and Lugansk People's Republic as terrorists, and the Russian Federation as supporter of terrorists and a persecutor of ethnic minorities. This stigmatization, if endorsed by the court, will serve Ukraine to justify its so-called anti-terrorist operation, which is being waged already for almost 3 years against these entities, and in fact against the population of the regions that constitute these entities. It appears obvious that Ukraine hopes that the tragic picture of the situation in Ukraine's east will cast its shadow on the situation in Crimea, and thus will stimulate the court to order provisional measures with respect to the Crimea-related claims. Ukraine, in the past 2 days, has often used the word similarity when turning to the situation in Crimea. Yet, there is no similarity at all. On Tuesday, I stated that Ukraine's purpose was to seek this court's decision on an alleged use of force by Russia, a matter beyond the court's jurisdiction. In reply to my statement, Professor Koh said, I quote, "Nor do we,
or will we ask you, the court, to determine the legality of Russia's aggression? Ms. Zerkal echoed his words. However, hours later, in an interview, she had this to say, I quote, "Currently, we request provisional measures. The court will consider the request and adopt its own decision. Possibly, the wording in this decision will not be the one that we request. However, the fact of legal recognition of the violation by Russia of these two international law instruments is very important for us, as in fact, recognition of that role, of that aggression that Russia conducts on the territory of Ukraine. The simple question is, which of these two positions of Ukraine is its true position? Yesterday, Ukraine disputed the relevance of the Minsk process to the present proceedings and stated that it did not consider the DPR and LPR to be official parties to this process. This argument, however, misses the point. The fact is that the representative of those whom Ukraine calls terrorists signed not only both Minsk agreements, but also a number of Minsk process arrangements, including a recent one, framework decision on the trilateral contact group relating to disengagement of forces and hardware. Ukraine engages with both entities within the trilateral contact group and its working groups established under the Minsk agreements. A meeting of one of those working groups took place just 8 days ago on the 1st of March. The representatives of the OSCE, Ukraine, Russia, and those whom Ukraine called terrorists all participated. Mr. President, Russia takes its obligations under both treaties seriously. At the same time, Ukraine's repeated suggestions that this should support the indication of provisional measures, since compliance with such provisional measures would be simple, does not provide a legal basis for the indication of provisional measures. It's not the function of provisional measures to remind states of their obligations. Notwithstanding the fact that the two cases are indeed different, when it comes to provisional measures, the same well-established test must be met in both cases. As we have demonstrated during the pleadings, Ukraine's request fails to satisfy this test in both cases. I will not recapitulate each aspect of Russia's position, but will address a few important points. With respect to the ICSFT, these are as follows. First, in over 800 pages of documents submitted by Ukraine to the court, you will not find a single statement of an international organization or body, or indeed a state other than Ukraine, characterizing the incidents which Ukraine relays on as terrorism or as financing of terrorism. International organizations and the whole world perceives the events in eastern Ukraine as an armed conflict and the actions of the parties to it as what they are, as acts of war. Consequently, Ukraine is alone in seeking to characterize the incidents it relies on as terrorism and the financing of terrorism. Second, as was demonstrated by our counsel, there is no basis for the court to exercise even prima facie jurisdiction in this case. Third, there is no risk of irreparable harm and no urgency with respect to the rights specifically under the ICSFT. I would also like to address shortly the issue of the evidence relied upon by Ukraine with respect to the so-called flow of weapons. This is not a point critical to the court's determination of the current issues, but we do this to register our very genuine concern. On Tuesday, Mr. Rogachev drew your attention to Russia's submission to the European Court of Human Rights, where it demonstrated that Ukraine had provided fabricated evidence as to allegedly Russian-supplied weapons. In this submission, Russia showed, for example, how Ukraine had mocked up its own paintwork on a Grad launcher to suggest it was Russian, and that Russian military symbols had been painted over to obscure its origin, and how boxes of military equipment had been decorated to suggest Russia's Russian supply. We have heard no response before the European Court of Human Rights, although Ukraine has had more than a year to consider it, and we heard no response on Wednesday either. Under such circumstances, Ukraine's evidence should be subjected to close scrutiny and cannot be taken at face value. This approach is particularly appropriate since the application has not been prepared on an urgent basis, and in fact, Ukraine has been preparing it for 2 years. Moving next to the request Ukraine bases on the third, I would like to make the following points. Ukraine asks the court not to believe Russia, not to believe many statements of residents of Crimea, but to rely solely on the documents of international organizations and also, as we learned yesterday, the US State Department. We have already pointed out the fact that the General Assembly resolution is a political document adopted by a split vote with 2/3 of the UN members either voting against or abstaining. In fact, even 2 states voting in favor of the resolution expressly dissociated themselves from the paragraphs of the resolution on Crimean Tatars. We also mentioned that international bodies, to the reports of which Ukraine refers, have no presence in Crimea, and therefore probative value of the reports is diminished in this case. Anyway, these reports do not refer to a campaign of cultural erasure of national minorities alleged by Ukraine. Moreover, Ukraine did not dispute that it used inaccurate information trying to prove that there was an exodus of people of Crimea. The weakness of Ukraine's allegations is illustrated by the many allusions in the statements of its team to the 1944 illegal deportation, which has no relation to the present case. Ukraine has been engaged for years in the practice of discrimination of Crimean Tatars, and now it continues with this practice on the territory under its authority. It also supports a blockade, which has a high toll on the residents of Crimea, whom Ukraine pretends to protect. It is for this reason that we have invited the court, applying the plausibility test, to look a little deeper into the facts, of course with the full understanding that this is not the merit stage. Given the alternative reality Ukraine construed, such an inquiry is necessary. As demonstrated in our pleadings today and on Tuesday, Ukraine's allegations under the third are not plausible, nor does the court have even prima facie jurisdiction. Finally, Ukraine has failed to demonstrate either risk of irreparable prejudice or urgency. Mr. President, before making our final submission, I would like to make one more remark. Ukraine repeatedly claimed that the purpose of its request is to protect the vulnerable population, and in particular those in the east of Ukraine, for whom the provisional measures, as claimed by Ukraine, are a matter of life or death. At the same time, the Office of High Commissioner of Human Rights issues reports submitted by Ukraine to the court that record Ukraine's armed forces, including volunteer battalions, engaging in indiscriminate shelling that leads to numerous civilian casualties in the east of Ukraine. Neither Professor Koh nor Ms. Chik had any answer to this. Those reports are coming from the OHCHR, who have presence on the ground. Similarly documented in those reports are numerous instances of Ukraine's armed forces, including volunteer battalions, and Ukraine's security service engaging in extrajudicial executions, torture, and enforced disappearances. And the list of crimes thus reported could be continued. Then a simple question arises. How could the state, implicated in such ruthless action against its own population, claim that it seeks protection for these people and ask for justice in the principal judicial body of the United Nations? The situation in East Ukraine is tragic, but to protect its population, Ukraine should begin to implement in earnest the Minsk agreements that are widely recognized as the only uncontested solution to the conflict. Mr. President, our final submission is as follows. In accordance with Article 60 of the Rules of the Court, and for the reasons explained during these hearings, the Russian Federation requests the Court to reject the request for the indication of provisional measures submitted by Ukraine. In conclusion, I would like to thank heartily the Register and his staff for their services during these proceedings, not forgetting the interpreters for their excellent translation in sometimes difficult circumstances. And of course, we thank you, distinguished members of the Court, for your patient attention. Thank you, Mr. President.
Je vous remercie, Excellence. Voilà qui clôt cette série d'audiences. Il me reste à remercier les représentants des deux parties pour l'aide qu'ils ont apportée à la Cour en lui présentant leurs observations orales au cours de ces audiences. Conformément à la pratique, je prierai les agents de bien vouloir rester à la disposition de la Cour. La Cour rendra son ordonnance sur la demande en indication de mesures conservatoires dès que possible. Les agents des parties seront avisés, en temps utile, de la date à laquelle elle en donnera lecture en audience publique. La Cour n'étant saisie d'aucune autre question aujourd'hui, l'audience est levée.